The Department of Justice now has a huge decision to make as it weighs whether to appeal the federal judge's ruling granting the appointment of what's called a special master to review documents seized during the FBI raid on Mar-a-Lago and pausing the DOJ's criminal investigation, at least with regard to use of those documents. The ruling was critiqued by just about every legal analyst, both left and right, politically, either mildly or ferociously, usually depending on their political leaning. I argued on the show last night that yes, the judge's legal reasoning was fundamentally flawed and that I believed her decision wasn't supported by the law. But I also didn't think it was that big of a deal. I also thought she deserved credit for stating that these are exceptional circumstances surrounding not just anyone but a former president. And while another judge might have pretended this was just the law she was applying, Judge Cannon seemingly admitted that she was applying a different standard because it was the former president. She said, quote, mindful of the need to ensure at least the appearance of fairness and integrity under the extraordinary circumstances presented. But that doesn't mean she got it right. And so now the ball is in Attorney General Merrick Garland's court about whether to appeal that ruling to the 11th Circuit Court of Appeals, a conservative court with 6 of its 11 active judges appointed by President Trump. The DOJ has a lot of justification to do it, in particular because the judge's ruling suggests that a former president may be able to invoke what's called executive privilege over documents that really belong to the government and not to Donald Trump. Now, whether to appeal is a close call for the DOJ, but former Attorney General Bill Barr, who served under George W. Bush and Trump, and who spent his career advocating for more power for the president, for the executive branch, he thinks the judge got it wrong and that the DOJ should appeal.
The opinion, I think, was wrong, and I think the government should appeal it. It's deeply flawed in a number of ways. I don't think the appointment of a special master is going to hold up, but even if it does, I don't see it fundamentally changing the trajectory. In other words, I don't think it changes the ball game so much as maybe we'll have a rain delay for a couple of innings.
Do you think the special master will be overturned on appeal by the DOJ?
I think if DOJ appeals eventually, it'll be overturned.
How long will that take?
Well, that's why it could be delayed. I hope they expedite it, but it could take several months to get that straightened out.
And that brings us to the crucial issue, which the DOJ has to weigh here, timing. Because an appeal would slow everything down. Months, as Barr said, to get everything straightened out. And it could get denied, which would mean the special master review has to start from the beginning. There's also the possibility that the DOJ wants to follow its unwritten rule of not taking any action within 2 months or 60 days of an election that could be construed as an effort to affect it. In this case, that would be the midterms, although Trump is, of course, not a candidate. And yet, on the flip side, the special master process itself could take a long time. Remember, there are 11,000 documents to go over with a fine-tooth comb. And the DOJ use of the documents in its investigation is paused until that review is complete. And what if there are disputes over certain documents that the special master finds are covered by executive privilege or attorney-client privilege, but that the DOJ does not? Those arguments would have to be sent back to the judge to resolve, and that could take additional time. So in that respect, it could be better to appeal now. Also, they might get better treatment from the judge if they just accept it, but who knows? But they also may not want to allow the judge's ruling to become the basis for what's called legal precedent, especially because it is just a faulty legal ruling. Prosecutors may only have a few days to decide because both sides need to submit names for a potential special master by Friday. Joining me now is Stewart Gerson, former acting attorney general under President Bill Clinton and assistant attorney general for the DOJ's civil division under George H.W. Bush. Thank you very much for coming on the program. Appreciate it. All right, so what do you, first let me ask you, before I ask you what you think they should do, let me ask you, what do you expect that the Department of Justice is going to do here?
Well, Dan, I don't know. Merrick Garland has played everything very close to the vest during this time. Bill Barr and I have disagreed about a number of things in recent months, but not about this. This opinion is very poorly reasoned. The judge is supposed to follow the law, not invent a policy that somehow supersedes what the law requires and wades into an area that really is the prerogative of the executive, that is executive privilege, and is way premature because under normal circumstances, as you well know, having covered court proceedings for so many years, These become timely when the government seeks to introduce something and then a court rules on it. None of that is present at all. But what is the department going to do? You've stated good reasons to appeal because the opinion is so flawed. I doubt that it would be considered precedent by almost any other court. It really doesn't bind anybody at all, other than this particular judge, who's a trial judge, and it's so badly flawed, criticized by liberals and conservatives alike for very good reasons. It just isn't the law, so the department may just let things stand and move along, because there are some things the department could do immediately. I mean, irrespective of claims of executive privilege. Go ahead.
That's what I wanted to ask you about. I mean, because they can continue with this investigation now. It's not, people I think are under the misapprehension that somehow they have to stop the investigation. They don't have to stop the investigation. They just have to stop the use of the documents in connection with the investigation. And so I wondered this. I actually don't know the answer to this. Let's say that in 2023, the special master thing is still going on. They're still fighting over documents. There's still questions, et cetera. And in February, the Department of Justice says, you know what? It's time for us to indict. Can they indict, if they haven't appealed, can they indict and then use these documents in the course of a prosecution?
Dan, you don't have to wait till February. They could do it tomorrow.
Right.
And the reason why they could, now there may be some documents that would never be admissible, attorney-client privilege documents that are personal to Trump, not the presidency. But as far as these classified documents are concerned, you remember during the campaign when then candidate Trump was attempting to lead cheers of lock her up with respect to Hillary Clinton's taking away classified documents or having classified documents on a personal server? Well, that's the same sort of thing that Sandy Berger and John Deutsch and David Petraeus all had difficulty with. The mere fact that Trump had these classified, highly classified documents, there's no question about what they were, and the fact that he had them, that they were at his country club. One could deal with that tomorrow. You don't have to wait till February. Now, there are other issues where you have to look further.
But here's the thing. It's not going to happen tomorrow, which is why I'm trying to give a realistic scenario, right, as to the way it could happen. It's not going to happen tomorrow. We know there's not going to be an indictment tomorrow based on what's happening, which is why I was sort of asking it as more of a hypothetical, which is that they wait, they continue their investigation. But again, the crucial point that you're making is they could still use these documents in the course of a prosecution, even if for now they're not allowed to use them in the course of the investigation, correct?
Well, in the course of a proceeding, yes, absolutely. They could be used in the course of the investigation. I was being hyperbolic also, just to punctuate your point that this could be done at any time. I think the window is closed right now. Merrick Garland has indicated that. So there will be some time, but the government can pull the plug on this. Now think about this. For example, let's assume that there are a whole bunch of documents that are subject to executive privilege. With respect to prosecutors, so what? Executive privilege pertains to documents that are the possession of the executive. The prosecutors are part of the executive branch. Of course, they can see those documents.
Well, that's been the flaw, one of the flaws in the judge's ruling, by suggesting that she's sort of leaving it open, that at least for now she's going to allow them to investigate that. But bottom line, on whether they're going to appeal, what do you think? Tough to, I mean,
if they do it, it's going to be with you and with your point in mind, that they can pull the cord at any time they want. If it moves quickly, who knows? I mean, it might take forever to come up with a special master that's agreeable to both parties, or that may have to be appointed by the trial judge. So, they'll submit their lists. That could lead to a long-term dispute. This could go on for a long time for the reasons that you, Bill Barr, and others have described.
You mentioned Bill Barr, and I do want to play something else, which I found very interesting, because he spoke out today about whether the DOJ should indict Donald Trump, which is, of course, the big question. Here's what he said.
You know, as I've said all along, there are two questions. Will the government be able to make out a technical case? Will they have evidence by which that they could indict somebody on, including him? And that's the first question, and I think they're getting very close to that point, frankly. But I think at the end of the day, there's another question: is do you indict a former president? What will that do to the country? What kind of precedent will that set? Will the people really understand that this is not, failing to return a library book, that this was serious? And so you have to worry about those things, and I hope that those kinds of factors will incline the administration not to indict him, because I don't want to see him indicted as a former president. But I also think they'll be under a lot of pressure to indict him, because, one question is, look, if anyone else would have gotten indicted, why not indict him?
Stewart, Gerson, final thought on that?
Well, I agree with all of Bill Barr's analysis except his conclusion. I think we've gone over the line, and that to preserve the rule of law, that further action is going to be required.
Yeah, and I guess I'm not that sure yet. I think that it is such a dangerous thing for the country to do. I think Bill Barr's warnings there are spot on, but I'm not saying they shouldn't. I'm just.
No, they're legitimate warnings.
Yeah, absolutely.
All right. He says it, I say it, and to be determined.
Yep. Stewart Gerson, thanks so much for coming on the show. Really appreciate it.
Thanks for having me.
Coming up, a Las Vegas investigative journalist stabbed to death outside his home. And today, thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.